Lordship, I beg to mention item number 11.
Number?
11, I've taken the consent of Mr. Sangriso.
Item number?
11.
11.
Your Lordship is pleased to fix this matter on Wednesday, 21st.
Next. Come in due course. You are for?
I'm for the respondent number 6 and 7.
Who's for petitioner?
Petitioners.
On pre-made by the respondent 6 and 7. Not objected to by petitioner. This is matter after 2 weeks.
All right.
Your Lordship, I beg to mention item number 13, Your Lordship. The conducting counsel is on sanction leave.
You are for?
I am for the petitioner, Your Lordship.
I'm for respondent 3 and 4.
On pre-made by the petitioner. This is matter after 3 weeks.
My lord, I beg to mention item number 14, my lord. I need some more time for do the final hearing, my lord. I'll inform Mr. Sharma.
Have you informed him?
I'll inform. I was waiting for him. I'll inform him the moment he comes.
On pre by the state respondent, matter is adjourned. This is same after 3 weeks.
Highly obliged.
Please, Your Lordship, I beg to mention item number 15. Your Lordship, it's a joint mention.
For the respondent.
On pre-made by the parties. This is matter after 3 weeks.
I beg to mention item number 8, my lord. I will fix it some other day.
2014 matter.
My lord,
I said it's a 2014 matter.
fix it next week, my lord. No objections, Your Lordship.
That's subsidy matter.
My lord, this is subsidy.
On pre-made by the petitioner. This is matter after 1 week.
I beg to mention item number 17. The conducting counsel, he is unwell. Mr. S. Sheikh is the conducting counsel.
What is this matter about?
Maintenance, Your Lordship.
Maintenance.
Your Lordship, no for the adjournment, Lordship, on the next.
Huh?
Because many times they have asked for
You are for?
I am for the respondent, my lord.
Can we pass the order, Your Lordship, no for the adjournment?
Lordship, Mr. S. Sheikh, he is the conducting counsel and he is unwell.
1 week?
Kindly one.
Yes, maintenance matter you should.
Yes, my lord.
Does it involve interim maintenance?
Yes.
Interim, are you still getting interim maintenance or?
No, Your Lordship.
1 week.
Praise made on behalf of the respondent on the ground that the direct conducting counsel, Mr. S. A. Sheikh, is indisposed. The letter counsel for the petitioner has, however, objected to the prayer made on the ground that this matter has been adjourned for on many occasions on the prayer of the respondent. Be that as it may, on prayer made the same is allowed. This matter will now appear a week hence. No further adjournment will be allowed.
Master.
I beg to make mention of item 12, my lord. It's kindly listed after 2 weeks.
On prayer made by the state respondent, not objected to by petitioner, this is matter up to 2 weeks.
Obliged.
Supplementary cost list, item number 1.
Mr. Sen Melons had made a request for this matter to be taken up today.
Oh, there are only two respondents.
Well, it's only two respondents. Respondent number one is the private respondent
course, this
who I was representing, or at least instructed to represent.
So when did she expire?
And it's on 22nd of February 2019.
2019. Mr. Sen, what happened?
That's exactly. I'll just point out, Manoj. On 2/6/2023, when this matter was listed, my learned senior friend had indicated that she had expired. I was not aware of this. And he also made a mention that there was
But you're holding the brief, Mr. Sen.
Correct, Manoj, correct. I'll just come to that, Manoj. What's happened really? I immediately went and got in touch with the son. And he informed me that the mother had expired in 2019. And at that point, the councils were a different set of councils. And he had instructed the councils to take whatever steps were necessary, but apparently they did not take any steps. Now, something even further has happened. I was engaged in the matter only in 21, and I was asked to appear by way of a different vakalatnama. Now, I must tender my apology, Manoj. This is a very serious issue that has happened. I was not informed about it at all. And surprisingly, Manoj,
who has signed the Vakarnama?
he himself signed it because he was under the impression that his name had been substituted in the matter. Now, kindly see, Manoj, if Lordships will have the order dated 29/7/2019.
Yes.
So, this was the first time the counsels for the petitioners had brought it to the notice of the court that the respondent number one had expired. And can you see, it states that learned counsel for the petitioners says that respondent number one, Srimati so-and-so, has died in February 2019. Learned counsel for the respondent number one prays for time to verify the said fact, adjourned to 23/8/2019. Lordships can go through the entire series of orders thereafter. Nowhere have either of the parties made any attempts to verify the death. I understand it falls for the respondent's counsel to inform the court. Apparently, I'm told that they were informed about it. They were also instructed to file necessary applications for substitution. None of that was done. I'm not really sure why. Subsequently, they were disengaged, and so I entered appearance on 16/10/2020. Even at that point, I was not aware that she had expired. He had not informed me about it. So there was a very serious miscommunication. I apologize for this, for whatever has happened. I was not aware about it at all.
What do we do in such a situation?
Well, so I can't really represent any of the parties at the moment till I get instructions for substitution or otherwise.
Hey, Mr. Paul, you're aware of this fact?
Well, I had informed the court in 2019 that she was no more.
It was incumbent upon you to take steps.
But my lords, we'll also go through the entire order sheet. Nowhere have any further attempts made to indicate that the case is abated as against the respondent number one, or any further attempts to substitute. Case was repeatedly fixed for hearing. I appeared for respondent number one in 2020. No mention was made that I cannot appear for a deceased person. So, although the fault is mine, I did not.
Even the court was taken for a ride.
The fault was entirely mine. I should
It's
have
not
checked
that,
the brief.
well, it's what issue happens over here is, and what my learned friend had indicated to your lordships yesterday, that the respondent number one was the original complainant in respect of whom certain orders had been passed by the deputy commissioner as against me, that is the petitioner before your lordships. There was no corresponding favorable order passed in favor of the respondent number one, Millets. So insofar as the respondent number one for the purposes of adjudication of this particular revision petition before your lordships is concerned, Millets, my humble submission was that her participation in these proceedings, or Millets, the question of her heirs stepping into her shoes does not arise. Had there been a corresponding right created in her favor, Millets,
So even if the matter is abated, so makes no difference.
Well, if that is the case, then why was she made a party in the first place?
Because at that
That
point of
begs
time
the
she was
question.
alive, Millets. At that point of time
But if
was
she
alive.
had no right at all, she ought not to have been made a party.
No, the question here as well as I think insofar as my learned friend is concerned, his only explanation to this honorable court was required to the extent, Millets, that who he was appearing on behalf of whom. I think my learned friend was instructed by the son, Millets, who was not a party to these proceedings, and that aspect of the matter is clear. Now the question is, the lordships will then consider, my lords, after hearing the matter, whether at all, my lords, there is a occasion whether the right to sue survives or any right survives upon the heirs of the deceased, my lords. And then your lordships will take an appropriate
Yeah,
call.
that should.
That stage has not come, so I don't think my learned friend has.
I'm not sure when that stage will come because
And
from
we have to-
2015 the matter has been pending. From 2019 the case has been repeatedly fixed for hearings,
In view of
despite the fact that somebody has expired.
in view of Order 22, so now we have to cross a hurdle of limitation.
Lordships.
Hello, sir. But that's there. The issue will be whether I am required to cause the substitution or they. In my understanding,
If
this is
at
not a
all,
civil
my lords,
suit. This
if
is not a
at
civil
all
suit.
There is a requirement of substitution. If at all.
Yeah, no, it's incumbent upon the petitioner or the appellant.
As far as I understand, because this is a revision under 227.
Even so,
It is not a continuation of the original proceedings, my lords. It is not a continuation. So the right to sue does not survive to the respondent number 2.
That is settled, of course.
So the right to sue does not survive to the respondent number 2 alone. So anyway, that lordships will examine. If at all I do have instructions to make an application to set aside the abatement and so on, I'll make that in due course.
That's the call of my learned friend, my lords.
So the ball will be in your court then.
Well, my position is very clear. I have indicated to your lordships, nothing survives insofar as the heirs of the deceased are concerned. It is like, my lords, I file an FIR. On the basis of the FIR, my lords, the case is charge sheeted. Merely because the death of the complainant will not ensure, my lords, that the heirs of the deceased will come in. Unless there is a corresponding right created by an order, my lords, in her favor. That is not.
The actual issue is yet to be determined.
Your lordships will examine.
Anyway, I'll leave it to lordships.
Your lordships, sir.
So when
We'll have it sometime next week, my lords. Your lordships may hear us on Monday or
who's the
Tuesday.
PF for the state?
State, Mr. Sengupta is there, my lords.
You're there.
No, today is not available. Here in Pop.
Mr. Sengupta is appearing.
No, I'm here, deputy commissioner as well. So more or less a formal party.
Who's a formal party? Who's not? I fail to understand.
No, they are not the formal party. They are the party who's passed the order.
But you have come in revision.
I have challenging the order of the deputy commissioner as well as of the revenue board, my lords. Because deputy commissioner passed an order against me. I challenged the order before revenue board. Revenue board held, my lords. I have no locus to challenge that order. Against that, I'm before your lordships. Have it on Monday or Tuesday, my lords, subject to your lordships' can convenience.
Premier with parties. This is matter. 1 week.
Daily cost list. Item number 1.
Your Lordship, this is a matter of
what's the
process
progress?
of compounding.
The progress here, Your Lordship, is that we are trying to compound for the financial year of 14-15, 15-16, 16-17, 18-19, whatever is the due. So what has happened now, because this...
Mr. Pulang, sorry to say, if I play a tape recorder here, I would hear that submission would have been repeated.
Yes.
Up in time.
Just to refresh Your Lordship. So what happened today, the latest instruction is that we had sent those applications for compounding from Shillong to Guwahati, and they have received it this morning. So our chartered accountant who is appearing for us before the ROC is filing it today itself. The moment it's filed, he'll send us the application. I'll place it before this court.
So how long?
And it will take up 4 weeks, Your Lordship.
I think so by 4 weeks also the matter will be closed. Then the only issue will be that...
Because the issue of compounding will not come before this court.
No.
That would be in the trial
That would
court.
be with those subsequent years. The issue before this court is 13-14, which that 148 has not been come to effect.
The only thing is that you will link those compounding proceedings
they're
with
saying they made a mistake. It should be 14-15.
Your Lordship, if the company order pass, then ultimately order will be withdrawn. So then no proceeding is surviving.
Exactly.
And they'll have to withdraw it in the trial court.
On pre-made by the parties, this is matter after 4 weeks.
Obliged.
Item number 9.
This is a part of matter relating to Assam rifles.
Elusive, in last occasion, I just went to this court to bring to the notice about the position of the petitioners. So it will take little bit time, Elusive, because some information to be taken from the unit because they are retired and not yet been completed this all information.
You're supposed to file additional affidavit. Who's supposed to file additional?
I am supposed to file Elusive indicating this when they have retired and all information. So it is under process, Elusive.
What is this case about, Mr. Riso?
My lord, this is a restructure of pay and application of pay scale that was granted by this court and even upheld by Supreme Court.
5th CPC?
My lord, not fifth CPC, changing of the rank structure
Okay.
and the pay revisions, the pay revision. It is already upheld by this court in our Supreme Court. Now,
I'm told, if I'm not mistaken, a series of related matters emanating from this court as well as from other high courts, particularly Guwahati and Tripura and Manipur. The union have approached the Supreme Court in this.
they also fail.
Whether it's pertaining to this or pertaining to this parity in rank and pay structure, as far as those traits are concerned.
Maybe many litigations are there arising from Assam rifles, and this one is confined to rank structure and the revision, and this was allowed, and the government has implemented also. Later on, my lord, they have taken another plea that this rank structure is not applicable to the categories of employees who wants to become the second in command, and for them to become a second in command, my lord, one has to face the promotion test.
Because this is
normally
that limited exam.
limited exam. Because the Assam rifles, higher officers are controlled by the army, and the lower ranks are directly recruited from the citizen. So they say that to become a second in command, one has to face this limited selection process. My lord, that issue raised up before this lordship, and lordship has dismissed that writ petition, and I was informed that the writ appeal is pending. That is separate issue. But with regard to my issues, my lord, this court has upheld and even Supreme Court has upheld, and they have implemented. It's a similar. It's Radhakrishna Nair versus Union of India.
That is exactly what is the challenge now before the Supreme Court.
That one is, my lord. It is no longer, so far as my information is concerned, that judgment passed in Radhakrishna Nair, it was upheld by Supreme Court, and they implemented. Now later on, though some of the petitioners they asked for promotion to the rank of second in command, that was denied by the department. So they approached before this court, but lordship has rejected that petition, upholding the contention of the state respondent Union of India that you have to face the limited selection process to reach the status of second in command. So that is pending division bench. In my case, my lord, the lowering officers, well, this is our priority, is a cover case, and it's not a contention of the learned CGC that judgment is not applicable to me. It's applicable to me. His only concern is that some of them retired.
Yes.
It is not cover. And we filed in 2016. That exercise he wants to do in 2013.
But
very difficult to understand also.
What you want to do is you want to go through your records and find out who is.
Yes.
So, in principle, you would agree with Mr. Sangreso that this is a covered case.
Elusive here in this case, suppose here in this, so I got some this reference. Person is written 31st/10/1993. So this fifth commission and rank structures come in 1997. So when this person is even 1993, then they will not be covered.
See, then we'll have to look. We'll have to look at the revised and the pre-revised scale.
Yes, sir. So if they retired earlier, the pre-revised scale automatically it will be considered and already may be given. So here in this case, when the people they have retired, even some 96, so they are 92 also there. So you will see so many years 91 also there.
But this court has given you ample time, Mr.
After 6 years of litigation pending here, but he's bringing one page of
Some is
1 2-page paper.
91. So this
Very
is the matter.
difficult.
When just I was going through the after this.
But Mr. Sangresu, what you can do, as far as you are concerned, it is also, it would be fair on your part also to bring out that list from the list of petitioners herein as to who has since, retired, who are still. You could have done that.
But that we have already done in the writ petition.
You have done
deny.
that.
They don't deny it.
Then
That is why, madam.
Then what's the
This
what's the grievance of
basically
Mr.
this person who was retired earlier. It is
96?
1996. And in my writ petition, we have given all the categories of writ petitioners. Serving petitioners are there, retired persons, and the legal heirs are there. And he is not denying in the affidavit. He admits that Supreme Court order, this High Court is covered to my case.
So if I didn't bring this notice of this honorable court and this order passed, then all the MP of the Assam Rifle, who were there earlier also, then they'll be coming purview of this by this court.
As and when they come, why are you? It's not for you or for me to speculate.
So elusive, then it will be admission by the.
No.
This will be the admission that
We are looking at the case of the petitioners. If they are entitled, if they are covered by the order of this court and the apex court, then that's it. You have to abide by it. This court has to abide by it. There's nothing to it. As and when you see anything comes out of that, then you have to deal with it at that point of time.
So elusive, at the moment, if I didn't bring before this,
you have done. Ample time have been given to you.
So elusive, this we are collecting the information from the concerned bunch, and then so many.
Fine, I'll do one thing. I'll give you a last chance. Whether you come up with any explanation or not, we'll dispose of the matter.
With Lordship permission, I will add, cost may be imposed to the respondent.
We'll see.
The concerned officer, my lord, dealing with the records, negligently handling the case, resulted to, my lord, the prolonged litigation here, wasting the precious time of this honorable court, languishing of the applicants, petitioners here, is responsible by the concerned officers.
So I'll hear you.
So
Mr. Ardepnat has, CGC has submitted that the affidavit, additional affidavit directed to be filed for this court could not be done so. It is noticed that this prayer has been made time and again, and on this ground, this court has accommodated the parties. Looking to the fact that the matter is a long pending one, the Respondent Union of India is allowed one more chance to present before this court all relevant papers or to get specific instruction so as to enable the matter to proceed in right earnest. Accordingly, matter is adjourned with matters adjourned. It is however made clear that no further adjournment will be allowed. As prayed for, this is matter of the 3 weeks.
This becomes a little bit more because so many information we
4
collect.
weeks.
Item number 10.
10 also same you lose.
Mr. Sangresu, you
Sorry, it's connected. It's connected.
Same.
same order.
Same order.
Item number 16.
Yes, Mr.
Lordship, I will crave your Lordship indulgence for some time.
What is this matter about?
This is with regard to ACR, Lordship.
ACR.
That is the second round of litigation. Order was passed by the coordinate bench directing us to file representation before the authorities. That was rejected. But the ground of rejection was that it'll open a floodgate to other people, not on merits of my.
But why has this matter come before this court?
Because this is a 2021 matter.
21. This is not. I think this court is not having the roster for that.
And plus, Your Lordship, the bench is disabled because I'm appearing in this matter.
On prey made by the petitioner, this is matter after 3 weeks.
Obliged.
Item number 18.